Okay, hey Spanish Springs. This is lecture number 4 on civil rights, civil libs, and this is for everybody, 0 periods, the whole shebang, pages 9 through 12 in the lecture notes. All right, today it's all about equal rights. So we move away from substantive due process, procedural due process, ideas like speech and religion and all that. We move into this concept of equal rights in American society. And so we generally look at equal rights in the context of, if you look on page 9 and 10, we talk about generally gender, equal protection or equal rights. We talk about African Americans, Hispanics, and Asians in the sense of this struggle for equal rights, right? And then we move into the Equal Protection Clause with notes 11 and 12, all right? And so I guess we should remember that the 14th Amendment has the Equal Protection Clause, all right, which kind of demands equal protection under the law for all people, all right? Now the definition of equal protection is has changed throughout American history to be more and more inclusive as we kind of move on in American history, all right? If we look like kind of just really quickly at 9 and 10, we look at gender, all right? And generally, women in American society, we see this first feminist wave, and the big push for gender equality in American society was suffrage, the right to vote, right? And that big push is the 19th Amendment, which basically says that women have the right to vote, that the right to vote will not be denied on the basis of gender. Okay, and now this second wave is kind of 1960s to the present, as the notes say, and it goes beyond just political equality with the right to vote, but into other things. And so you get things like the Equal Pay Act, all right, which is pretty straightforward, I guess, all right. Title VII of the Civil Rights Act of 1964, which said you cannot discriminate at a workplace based upon gender or sex again. All right, and then you get Title IX, which I know some of you know, of the Education Act of 1972. So like Title VI, Title IX, these are parts of these bigger pieces of legislation like the Civil Rights Act of 64 and the Education Act of 1972. All right, and again, what Title IX says is it prohibits gender discrimination in federally paid for education programs, including athletics. All right, and the idea was, and I know this is pretty controversial, where there needed to be some equality or parity among women's sports and male sports, academic programs as well, all right? And those were kind of the legislation. Now, lawsuits, we get a couple lawsuits, all right? Reed versus Reed says that just arbitrary or random gender-based discrimination is a violation of the Equal Protection Clause of the 14th Amendment. All right. Now, Roe versus Wade, which we're going to talk about in a little bit, is generally thrown into the idea of women's rights because of the abortion decisions and women being the ones that are pregnant. So it's generally thrown into a woman's issue. All right. But I know that is, you know, maybe we have rights of fathers, we have rights of the unborn fetus, and so it's a pretty complex issue, but it's generally thrown into the struggle for equal rights or control over their own body. Now, remember that Roe v. Wade it uses the precedent of Griswold v. Connecticut, which says the right to privacy exists, and then Roe v. Wade, you know, essentially says that the right to privacy then extends for a woman's right to choose to have or not to have an abortion. All right? And we'll talk about that in a little bit in a different context. Now, if you look at electoral politics, it's funny, the AP Board loves this question. 1992 was the year of the woman. A ton of women are elected into Congress. And I think, you know, the data here I have in the notes is the 111th. There's 74 women in the House and 17 in the Senate. Let's make that an extra credit question for tomorrow. All right, what are the numbers in the 113th Congress right now? All right, for the number of women in the House and the number of women in the Senate, okay? Now, this idea of a gender gap. Remember that this gender gap was generally that women tend to vote more Democratic than Republican for a variety of reasons, and that created a gap among the genders in how they voted. I think you generally see, like with these security moms, that gender gap has been shrinking a bit. all right, that there's a little less and less of a difference among gender, but we know that women generally tend to vote Democratic. Now I know, remember, that's a stereotype from Unit 2 that we used, but it's a general trend or a pattern, and men tend to generally vote conservative. But again, it's going to depend on a whole variety of factors in cross-pressure, which we talked about before. Okay? All right, now with African Americans, all right, what we say is we have 13% of the population, all right, and a couple important court cases. Dred Scott, originally in 1857, basically says that slaves are not citizens and don't have the right to sue. All right, that's kind of the big, Dred Scott is in a state that it does not allow slavery, tries to get into court, tries to be free, and they basically say you don't even have the right to come to this court because you're not a citizen, which is generally considered, not allowing equal rights for African Americans in American society. Now, the Civil War amendments, which we've been talking about, protect blacks against state governments. And in state governments, they're generally referenced to the South. So the 13th, 14th, and 15th Amendments, all right? The 13th Amendment ends slavery. The 15th Amendment gives African Americans the right to vote, all right? And then the 14th Amendment, which we have, it basically makes African Americans citizens, and it also has the Equal Protection Clause, as well as the Due Process Clause that we talked about before. And the key there is that no state shall, right? Which was the North going after the South following the Civil War and saying, look, you cannot discriminate on the basis of race. Now, what you get following the 13th, 14th, and 15th is the interpretation of the 14th Amendment's Equal Protection Clause in Plessy v. Ferguson, which essentially, as you know, says separate but equal is the definition of equal protection under the law, right? Which paves the way for Jim Crow and discrimination in the South, all right? And that's 1896, which defines the Equal Protection Clause as separate but equal. And then allows Jim Crow. If we bump forward to Brown v. Board, 1954, which essentially overturns the precedent set in Plessy v. Ferguson, which says that separate but equal is not the correct definition of the Equal Protection Clause. Now, a couple things there. You see in the notes that it says de jure segregation. De jure means by law. So African Americans in the Civil Rights Movement used the courts to fight de jure or legal segregation, which was established under Jim Crow and the Plessy decision. All right? De facto segregation is not legal segregation, but kind of segregation that exists not in the law, but people segregate themselves based upon race, they segregate themselves based upon gender, they segregate themselves based upon economics, that kind of thing, which is a whole different ballgame, all right? But de jure or legal segregation is what Brown v. Board was fighting. And again, remember, there's Brown v. Board 1, but there's also Brown v. Board 2, which says, you must desegregate now. All right? It wasn't, hey, don't desegregate later. It means now. All right? And then we saw in the video that Eisenhower actually still had to enforce that decision in the South. All right? Now, that's that for right now with African American. All right? And then if we move into Hispanics, again, we have 15% of the population, which I think this data is a little bit old. That number is growing. All right? And again, we have this idea of are Hispanics being treated equally under the law in the American society? Right now the Senate is taking up an immigration bill. This is something that's very controversial. This is something that is on the agenda right now in the U.S. Senate. All right? I know we have a couple decisions that basically say, like, bilingualism, and Lau v. Nichols, which said schools must take steps to help non-English speaking students. All right? States need to provide bilingual ballots in areas of high concentration of non-English speakers. All right? The thing about the Hispanic vote is both parties, I think the Hispanic vote has generally gone to the Democratic Party, but it's one of those things that we're seeing the Republicans address issues of immigration to try to appeal to the Hispanic vote, because Hispanics are a wide variety of people, right? They're not all voting one same block all the time. There's different issues. There's rich, there's poor, there's religious, there's non-religious, and so I think as we see the Hispanic community assimilating, you're seeing both the Republicans and the Democrats really working hard to go after that demographic. All right, but again, we saw that Barack Obama in both 2008 and 2012 won the Hispanic vote, where George Bush, W, had done pretty well, and Jeb, his brother in Florida, had also done pretty well. So it shows that they quite often call the Hispanic vote the sleeping giant. We have a lot of Hispanic people with the right to vote that could go either way. All right, and now what we see with the Asian vote, or the Asian population, is small, about 4%. All right, and the thing is here we talk about our Asians. Asians tend to come and do pretty well academically, economically, and so you actually have had, as we're going to get into affirmative action in a minute, this idea of reverse discrimination, that the Asian population was doing so well in schools they were actually being kept out because they were competing and gaining all these seats, and people were saying, well, they're 4% of the population, but a bigger percentage of students at elite universities. All right, so let's move into equal protection under the law, which is pages 11 and 12, all right? And so what we have is, you have this idea of discrimination. And discrimination simply means treating one group of people differently than other people, all right? Classifying or treating groups differently, all right? And now, some discrimination is inevitable. There's age requirements for driver's license. There's age requirements for drinking. There's age requirements for voting. They're generally going to consider that kind of discrimination okay, all right? But the 14th Amendment is the key here, all right? The 14th Amendment's Equal Protection Clause bans governments from practicing unreasonable discrimination. Now, like speech, where we saw those different tests, right? We saw those different tests about which speech can be used and which speech cannot be used or pressed. The same kind of tests are going to be applied here. Now, if you look at on page 11, we have the rational basis test. And what that means is the discrimination is going to be okay or constitutional if it has a reasonable relationship to the proper purpose of government. All right? Now, what that means is examples of this acceptable discrimination. They don't allow polygamy, marriage age, prohibiting felons from obtaining teaching credentials. Treating some people differently is going to be upheld, all right? Now the key here is this is called the rational basis test. And the rational basis test, if there's a reasonable relationship to the proper purpose of government, it will be allowed, right? But they can't use this if it involves a suspect class, an almost suspect class, or a fundamental right, which we're about to jump into. So let's get into the suspect class test, which is strict scrutiny. All right, and what this means is, first of all, a suspect class is a group that has historically suffered unequal treatment on the basis of race or national origin. Now, here's the kicker. When the government discriminates on the basis of a suspect class, the government must prove why this is acceptable. All right, and what the courts have said is such discrimination on suspect classes, there must be a compelling purpose. They apply strict scrutiny to this kind of discrimination for it to be constitutional. All right? So, strict scrutiny when they use suspect class, which is a group of people that have been discriminated on the basis of race or national origin in the past. All right? Now, this also brings us to this idea of affirmative action. All right? Now, remember that affirmative action was trying to right the wrongs of discrimination in the past. But what that bumps us into is this idea of reverse discrimination, right? The people that weren't historically discriminated against in the past were being maybe put down to allow those past suspect classes a head start or a bump up. We have this reverse discrimination, all right? And now this gets us into this idea of Bakke versus UC Regents versus Bakke, all right? What you had in Bakke was you had a white medical student who claimed and proved that he was passed up by lower qualified applicants solely on the basis of race. The UC schools were allowing minorities in, suspect classes in, ahead of highly qualified groups. Now, they were using race as the only factor. And what Bakke said is you cannot use race as the only factor. So you can't say, well, we have this highly qualified person here, and then we have this not qualified person that is a suspect class. We're going to let this suspect class person in, even though they're not qualified. Race can be one of many factors, but not the only factor. And Bakke won his case. He said he was denied entrance into medical school and lesser qualified people were allowed in on the basis that they were a suspect class. Now, there's a series of cases, because affirmative action, as you guys know, is absolutely controversial. We have a case in front of the Supreme Court this year about a white woman who said she was denied entrance into the University of Texas because she was white, that there were other applicants from suspect classes that got in over her, and she's claiming reverse discrimination. That was this year. Now, in between, we have a number of cases. You have Richmond and Crosnan, which said it banned city set-aside programs, which meant programs in city like education, job applications, that kind of thing, if they set aside quotas for suspect classes, those are not going to be allowed. So again, race can be a factor, but not the only factor. Quotas have definitely been not allowed in affirmative action cases, all right? Now the Bollinger cases, you have Gratz and you have Grutter, both 2003, the University of Michigan, all right? Now, first of all, the Gratz versus Bollinger said, bonus points for race in undergraduate admissions cannot be used. So if you have, a suspect class and then a white kid applying for the University of Michigan, you cannot give points on the application for race. That's what that's what Gratz versus Bollinger said. Right now, Grutter versus Bollinger said that you can use race as one, which kind of almost upholds what Bakke said, is you can use race as one of many factors in admittance to the University of Michigan, especially their law schools, but it can't be the only factor. All right, still controversial. I know you guys are going to say, why is race even a factor? All right, but the idea is you can't give points that bump people up for race. All right, generally what we're kind of seeing, well, we'll get there. Now, we saw Shaw v. Reno and Miller v. Johnson earlier in the year, and we talked about reapportionment and redistricting. And remember that Shaw said racial gerrymandering is not okay, right? That you cannot solely go in and draw a district with the purpose of drawing a majority-minority district. Now, what Miller v. Johnson says that race cannot be the overriding factor in drawing the district, right? That if you unintentionally draw a majority-minority district, or that the demographics in that district ultimately produce majority-minority districts, it's going to be okay. But you can't go in there with the intention of purely drawing these racially gerrymandered districts. So, suspect class, all right? They apply strict scrutiny. If the government is discriminating, or somebody is discriminating on the basis of a suspect class, then they apply the strict scrutiny test to prove that that discrimination will be constitutional or not. Now, we bump into quasi-suspect, which applies the heightened scrutiny test, which is not as a strict test as strict scrutiny, not as easy as rational basis, which is going to allow some discrimination. But again, rational basis won't allow discrimination on the basis of race, a suspect class, an almost suspect class, which is quasi-suspect, or a fundamental right, which we're going to get into almost, which is quasi-suspect right now. Right? So quasi-suspect is sex, is gender. All right? And we generally know that women have, throughout American history and European history, they're been treated differently, equally under the law. Now what we know is there are some biological differences, but they're going to allow some kind of discrimination, which your notes talk about. States allowing pregnancy leave for women but not for men is probably going to be acceptable. There are some differences. I think a current controversial issue is what about women in the military as far as certain combat jobs. I know that the military has kind of set a policy they're going to allow women into combat arms. All right? Now, here's the deal with the discrimination on the basis of sex. States have to show that the law, the discrimination, bears some relation to an important objective. So what you can't say is, you can't say, oh, sweetheart, you can't do this because women are inferior to men. That's never going to be allowed anymore, all right? Male draft only has generally been upheld. That's discrimination based upon sex. The leave for pregnancy is definitely discrimination based upon sex, but there are gender differences, so they will allow some, right? But they won't allow these arcane or old things that women, are inferior to men, and they can do, men can do a better job, that kind of thing. That's not going to be allowed, right? Quasi-suspect discrimination applies a heightened scrutiny. You have to prove that it's the discrimination on gender is on some biological difference between the sexes, all right? Now, if we bump over to page 12, we get to this idea of the fundamental rights, right? Your fundamental right to vote, your fundamental right to a variety of things. If the government is a law that is denying you a fundamental right, they go back and apply that strict scrutiny test, which again, remember, they applied the strict scrutiny to the suspect class as well. All right, so if a fundamental right is being denied to a group of people, they're going to apply strict scrutiny. So again, your fundamental rights are those which are outlined in the Constitution, your First Amendment liberties, voting, etc. There are also those that aren't necessarily, but are implied, such as those Ninth Amendment things, right, like Griswold, things that aren't absolutely explicit, but maybe the courts have established later. And that leads us into the abortion cases, which I know this is controversial. You know, is abortion a fundamental right? I know we have all of you guys that are going to fall on other sides of the spectrum, but for our discussion here, it's thrown into the fundamental rights. All right, now remember, prior to 1973, states set their own policies regarding abortion. So there's going to be some states that allowed access, some states that didn't allow access. Right? In 1973, we get Roe v. Wade, which essentially says the right to an abortion is based upon the right to a privacy, which is implied in the Bill of Rights through Griswold v. Connecticut. Remember, Griswold v. Connecticut establishes that right to privacy. They take the first, they take the third, they take the fourth, and they take the ninth, put it in a kind of blender, mix it up, and shake it, and there you go. You have, you know, the right to privacy, which then the court uses that precedent of Griswold, of privacy, which says abortion falls under that, and therefore is a fundamental right. Now, what Roe v. Wade said was the first trimester is essentially untouchable. All right, a federal policy that no state could deny access to an abortion in the first trimester, or it violated this fundamental right. All right, now we get a couple of other court cases. Webster versus Reproductive Health Services doesn't overturn Roe v. Wade, but it does give a little bit more leeway, meaning states, you know, in more conservative places in our country, states in more liberal parts in our country, could have a little bit of difference in their abortion laws. All right, now Planned Parenthood v. Casey defines that leeway. And what Planned Parenthood versus Casey said is states cannot impose a, quote, undue burden on a woman's right to an abortion. I think what this was is there were states that were requiring, you know, that women take classes before they get an abortion, informing them what they're doing, showing them options like adoption and other alternatives. And so that was challenged, and they said, look, you know, you're denying this fundamental right of abortion. You can't do that. And so what Casey said is states have some leeway, but they can't provide undue burden. Now again, you know, you guys are smart constitutional scholars at this point. You understand that this idea of undue burden is going to be different in different parts of our country and according to, you know, different people in our country. So again, we don't have a perfect definition of what undue burden is. Now, you also get Gonzalez versus Carhart, and I really think you guys need to know Roe is the court case, but these other court cases kind of discuss it. The Partial Birth Abortion Act of 2003 was well, let's talk about it in class, all right, because I want to kind of clarify it with you as we talk about it, all right? So there's your abortion from Roe to Gonzalez, all right? Now, Bush v. Gore, again, voting is considered a fundamental right. And in Bush v. Gore, which is the controversial decision about the 2000 presidential election, what you had is the state of Florida. I think you guys, it's getting farther and farther back now, right? You guys were young at this point. But basically, the Florida Supreme Court said there needs to be a recount. And what you had is you had different counties in the state counting votes differently. All right, the way they were recounting was going to be different, and so what they said was counting the votes differently violated the Equal Protection Clause, meaning this vote wasn't going to be the same in this county as it was in this county, and therefore the recount essentially was a violation of the Equal Protection Clause, and it pushed the election towards President Bush. All right, and said no recount in Bush v. Gore. All right, and so the key here is I haven't seen it on the AP exam yet, but it seems like you've got to be able to link the counting of the votes in Bush v. Gore, which was challenging, as a Equal Protection Clause issue. Votes have to be counted the same in each county in this recount for it to be equal treatment under the law. All right, now number 6 here on page 12 talks about same-sex marriage. You guys know that 9 states allow same-sex marriage of some kind. All right, you know that the Supreme Court just heard 2 cases this year, the Defense of Marriage Act as well as the Prop 209. No, it's not Prop 209. I'm sorry, you guys. Prop 8. Proposition 8 in California, which did not recognize, that said California doesn't have to recognize or legalize same-sex marriage. All right? And so what you want to look at is that right to marry, same-sex marriage, a fundamental right? Which, again, I know that people are going to fall on different sides of the spectrum. And it ends up being, again, the idea of equal protection under the law. All right? Same-sex marriage, traditional heterosexual marriage, is it a treatment, equal protection under the law, which I know we've talked about in class, all right? Now, finally, you have this last one of gay rights with Lawrence v. Texas, which basically struck down a Texas law that banned sexual relationships between homosexuals. And it said that, you know, this violated the liberty part of the 14th Amendment's Equal Protection Clause, or Due Process Clause. You cannot deny life, liberty, and property without due process. And they said that this law violated that due process right, that liberty right, for sexual relations between homosexuals. All right? Okay, so I know that's a lot. I know that I didn't explain everything perfectly, but don't forget on the quiz, there's some extra credit, right, for both classes here. What court case incorporated freedom of the press? Use your book for this one, all right? To the states. What court case that we looked at last class said that states have to provide legal help for those who can't afford it? What amendment protects against cruel and unusual punishment? Court case that established the exclusionary rule, right? Remember this idea that illegally obtained evidence can't be used in court, all right? Eminent domain, what the heck is it, right? What are the 2 clauses in the Constitution regarding religion, all right? And what are libel and slander both forms of, all right? There's your extra credit. All right, thanks. See you guys tomorrow.